Good morning, friends. Let us go ahead with AIB 9 Set A, Part 1 of 2016. प्रत्येक दिवशी एक पेपर कंपल्सरी सोडवावा लागेल. Only 14 days are left. So we should go ahead and do all the 4 parts in one day itself. So I'll upload all the 4 parts of 2016 AIB 9 today itself. Please like, share, subscribe. So you will get intimation of my uploading of all the videos. We'll try to complete as far as possible. जास्तीत जास्त प्रश्न आपण सोडवले तर we'll have some confidence for this exam. So let us go ahead with this. As routine, we are just repeating the last question. So I'll repeat AIB 8 ka last question. 100th question was the doctrine of civil conspiracy was enunciated by the House of Lords in Queen versus Latham. And this is AIB 9, the set is of 2016. AIB 8 2015 ची होती आणि हा जो पार्ट आता अपलोड करत आहे तो AIB 9 चा आहे. So that we will continuously having all parts of 7, 8, 9, 10 and 11. So please find everything in my playlist. First question is state practice for formation of customary rule includes state actions and state claims. या ऑप्शन पैकी कोणतं करेक्ट आहे ते आपल्याला सांगायचंय. इट इज क्वाइट लिटिल बिट कन्फ्युजिंग. स्टेट प्रॅक्टिस फॉर द फॉर्मेशन ऑफ कस्टमरी रूल्स. स्टेट ऍक्शन आहे का स्टेट क्लेम्स आहे? सो बोथ 1 and 2 is correct. Whenever you are not sure of such a question, always opt for all of the above or both 1 and 2. Sometimes 80% I think it's correct. Second, the controller of certifying authorities in India must maintain a database of all disclosure records of one is certifying authority, cross certifying authority or a foreign certifying authority. आपण जरा कन्फ्युजिंग क्वेश्चन आहे. So 1 and 2 is correct in this. Foreign चा काही संबंधच येत नाही कंट्रोलर of certifying authority. So first 2 are correct. Certifying authority and cross certifying authority. A database control of certifying authorities कडे ठेवला जातो. Third question is under section 37 of IT Act 2000, the certifying authority can suspend the digital signature certificate if 4 option है. Subscriber is found guilty of malpractice, subscriber involving cyber terrorism, the subscriber requests for the same, and it is in public interest. So third and fourth is correct option in this. The subscriber request for the same and it is in public interest. Public interest ha खूप wide concept है. So always it is true. Wherever public interest is involved, the option is correct. So certifying authority can suspend digital signature if the request of subscriber and it is in public interest. Or in the case before cyber appellate tribunal, the appellant without legal practitioner cannot authorize legal practitioner, cannot authorize his relative who is neither his officer nor a legal practitioner to appear on his behalf. Cyber appellate tribunal च्या बद्दल आहे. The appellant cannot authorize his relative who is neither his officer nor a legal practitioner. Cannot appoint means there are norms who can be having authority to appear on his behalf. Fifth, in the light of Criminal Law Amendment Act 2013, Which of the following statement is are correct? Criminal Law Amendment Act of 2013. Statement सगळे correct आहेत. All of the above. As I said previously also, ऑप्शन मध्ये जेव्हा all of the above असेल तेव्हा जर काही खात्री नसेल तर सिलेक्ट करावा. 6. The offense of stalking upon second or subsequent conviction is cognizable and non-bailable. Stalking upon second or subsequent conviction. याचा अर्थ पहिल्यांदा प्रूव्हन आहे ती केस आणि सेकंड ऑफेन्स आहे, मग तो कॉग्निजेबल असेल आणि नॉन बेलेबल पण असेल. स्टॉकिंग अंडर 354 ऑफ IPC. 7. In kidnapping, the consent of minor is wholly immaterial. Consent असो अगर नसो पण तो मायनर असल्यामुळे तो इमॅटेरियल आहे. Under the provisions of Trade Unions Act 1926, any person who has attained the age of dash 18 years may be a member of registered trade union subject to any rules of trade union to the contrary. म्हणजे ट्रेड युनियनचे कुठलेही रूल्स असू देत पण तो व्यक्ती, the person, any person who has attained majority age, he may be a member of RTU. मग कुठलाही रूल असला ट्रेड युनियनचा तरी तो 18 इयर्सचा पर्सन he can be a member who is adult. 9. Spurious goods. Under the provision of Consumer Protection Act 1986 imply such goods and services who claimed to genuine but they are actually not so. Spurious good म्हणजे जे काही क्लेम केलं जातंय की so and so are the features of the goods and services, but they are not actually, they are lying about their goods and services features. So these are spurious goods. Who is liable to pay compensation in case of death or permanent disablement? Owner of vehicle will pay compensation in case of death or permanent disablement. State will not pay, neither the driver or insurance company. The person who is the owner of the vehicle is liable to pay compensation in case of death or permanent disablement. Indian Evidence Act applies to judicial proceedings in court. Tribunal, arbitrator किंवा दुसरा कुठला नाही. All of the above हा चान्स इथे नाही. ज्युडिशियल प्रोसिडिंग इन अ कोर्ट साठी इंडियन एव्हिडन्स ऍक्ट अप्लाइड आहे. ट्रायब्युनल्सला तो अप्लाइड नाहीच आहे. 12. Fact in issue means fact existence or non-existence of which disputed by the parties. Disputed हा शब्द महत्वाचा आहे. Fact in existence or non-existence of which the disputed by the party. Dispute असला पाहिजे. 13. A bailable offense, bail, is granted as a matter of right, both by police officer and the court. Bailable offense मध्ये कोणी बेल देऊ शकतं. कोर्टामध्ये जाण्याची आवश्यकता नाही. पोलीस ऑफिसरला पण तुम्ही अप्लाय करू शकता बेल देण्यासाठी. As it is a bailable offense and it is his duty to tell the accused that the offense is bailable. It is a matter of right. 14. The conciliation proceedings cannot be used as evidence in a judicial or arbitral proceedings. जो काही एव्हिडन्स आहे तो वापरता येणार नाही ज्युडिशियल किंवा आर्बिट्रल प्रोसिडिंग्स मध्ये. कन्सिलिएशन प्रोसिडिंग मध्ये काही गोष्टी रिव्हील केल्या जातात पार्टीज कडून, बट दॅट एव्हिडन्स कॅनॉट बी यूज ॲज in a judicial or arbitral proceedings. 15. The serious fraud investigation office takes up cases for investigations referred to it by central government. SFIO. सिरियस फ्रॉड इन्व्हेस्टिगेशन ऑफिस. कुठल्या केसेस घेतात? इन्व्हेस्टिगेशन्स रिफर टू इट बाय सेंट्रल गव्हर्नमेंट. 16. Directive principles are not justifiable but yet fundamental in the governance of the country. DPSP च्या बद्दल लिहिले, त्याबद्दल तुम्ही कोर्टात जाऊ शकत नाही, yet they are fundamental in the governance of country as they are directive and state will just try to go for that. 17. Who has the power to dissolve the Lok Sabha? President has power to dissolve Lok Sabha. मला स्पीकर वाटलं होतं, पण President has the power to dissolve the Lok Sabha. 18. An amendment of constitution can be initiated by introduction of bills for such purpose in either in Council of States or House of People. House of People is लोकसभा आणि काउन्सिल ऑफ स्टेट म्हणजे राज्यसभा. अमेंडमेंट ऑफ कॉन्स्टिट्यूशन कुठेही इनिशिएट केलं जाऊ शकतं असा याचा अर्थ आहे. आयदर बोललेले. 19. Which of the following is a function of Central Pollution Control Board under the provision of Section 16 of Air Prevention and Control Pollution Act of 1981 to improve quality of air? ए आणि बी होऊ शकतं, पण ते क्लिअरली हा एअर ऍक्ट असल्यामुळे टू इम्प्रूव्ह क्वालिटी ऑफ एअर हा मेन ऑब्जेक्टिव्ह आहे ऍक्टचा. फंक्शन काय दिलेलं आहे? सेंट्रल पोल्युशन कंट्रोल बोर्डचं इम्प्रूव्ह क्वालिटी ऑफ एअर. प्लीज रिमेंबर. 20. The destruction of fish by use of explosives or by poisoning the water is prohibited by Indian Fisheries Act of 1897. एक्सप्लोजिव्ह वगैरे वापरून जास्तीत जास्त फिशरीज करायचा प्रयत्न होतो आणि हे प्रोहिबिशन आहे, प्रोहिबिटेड बाय इंडियन फिशरीज ऍक्ट ऑफ 1897. 21. आपण 25 करूया म्हणजे कंटाळवाणं होणार नाही. आजच्या दिवसामध्ये 100 करूया आपण. सो टुडे इज 15th. वी विल फिनिश दिस AIB 9 set in today itself. 21. Section 10 of CPC does not apply to when the previous suit is pending in the foreign court. 22. Principle of res judicata is mandatory. It is not optional or the party choice. It is mandatory. 23. International law is weak law because there is absence of compulsory dispute settlement mechanism and independent system of sanctions. रिझन दिलेलं आहे वीक का आहे, कारण कंपल्सरी डिस्प्यूट सेटलमेंट मेकॅनिझम नाही आहे, absence of compulsory dispute settlement mechanisms and independent system of sanctions. Last question of this part 1. I'll read it out. Which of the following is not objectives of United Nations? Which of the objective is not the objective? विचार negation आहे. Establishment of democratic governments throughout the world. Definitely. प्रत्येक स्टेटची कंट्रीची जबाबदारी आहे ही डेमोक्रेटिक गव्हर्नमेंट असावं. युनायटेड नेशन्सची ऑब्जेक्टिव्ह नाही आहे. So 26th I will go for in the next part 2. Please like, share, subscribe. दुपारी 2 किंवा 3 वाजता मी हा सेकंड पार्ट अपलोड करेन. थँक यू. प्लीज सबस्क्राईब.